general counsel for the third largest title insurance company in the world.
Okay. All right, so it sounds like we've got kind of a mix between small, large, probably a mix between people who are doing, who are litigating, people who are focused more on the contractual nature of things. And one of the reasons that we're here today, it's obviously about professional development, and we're presenting on domestic violence protective orders. But these are really good ways for people to get litigation experience if they want it. Protective orders are discreet. They're fairly easy to learn, which is why I'm going to try and do that in an hour and teach you guys how to do them. I think that if you like going to court, I think they're an awful lot of fun. And that's the number one thing for why this is something that works for legal services. So, as Laura said, I used to work for an organization called Legal Services in Northern Virginia. Why they don't just call it legal aid, which everyone knows, I don't know, but they don't. And one of the major areas that legal aid focuses on is domestic violence, doing protective orders. When I first, my first job out of law school was just a miserable experience. Then I moved up here and started working for legal aid as the domestic violence staff attorney. And while I was there that first time, we came up with this program called the Attorney of the Day program, which Laura and I are working on sort of trying to reboot at this point, which is part of the reason we're going through this. And hopefully we're going to teach all of you how to do these, and hopefully you will come volunteer for legal aid in doing this. The idea behind it, it's the name of the program, which I've hated from the beginning, is just because it's really boring and way too descriptive, is we want to get an attorney for each day in the Fairfax County Juvenile and Domestic Relations Court who can handle any protective orders that are coming through on that particular day. And we're going to talk about those specifically, and then about legal aid generally, and what other opportunities there are for you as we go through. And I think you should have in your materials this presentation, and then we'll go through some of the other things at the very end. Feel free to interrupt at any point throughout to ask questions. I find waiting to the end, I at least tend to forget what the hell I'm talking about, so feel free to just go ahead and do that. So I'm not going to, my goal in this always is not to just read to you. I'm presuming all of you are literate. I'm going to go through this, highlight the things that I think need to be, and really just jump in if you have any questions. So without further ado, I'll go for it. I guess I'm going to flip through that. All right, so we've already sort of talked about today's goals in terms of what we're going to teach you on that. This is all going to be in Fairfax County that we're focused on right now, so a lot of the sort of practice tips I'm giving you are going to relate to Fairfax County. As I'm sure most of you guys know, with the state, anything that's in the state courts, we're a fairly Fairfax-centric area, and so that's why we're focusing on that. And then obviously the number 2 goal is to make everyone feel bad enough to volunteer.
I have a question.
Yes.
So we're members of the Bar of Virginia who are in-house counsel. So
I'm sorry, say that?
So members of the Bar who are in-house counsel.
Yes.
Myself, I didn't want to be admitted to the Virginia Bar because I'm already admitted to 3 other bars. So can we actually do pro bono cases in Virginia, or do we need to get the supervision of a lawyer?
Yeah, so that's actually a really good question, and I don't have that included in here because I forgot to update it and include that in there. But a couple of years ago, we started working, LSMB started working with, among others, Hunt & Williams and ExxonMobil, and they went ahead and launched a big effort to change that rule. So now you are able to actually appear, even if you are in-house counsel and you've been sworn in as far as that goes, then you can do it without even having a legal aid organization with you, and you don't need a Virginia attorney with you either.
It's a little bit nuanced. There's 2 types of corporate registrants. There's corporate registrants who are actually allowed to practice before courts in Virginia, basically full members of the Virginia Bar, and there's a second category who are not allowed to cover the second category.
I don't believe that it does. I would have to look at the specific rule, but I don't think that it does. I think it only includes, I think the idea behind it was we let these people go in and, as the people at Exxon explained to me, and discuss billion-dollar deals, but we won't let them handle a protective order. So I think that's it.
Do you have a contact at the, this is pretty, I actually go into a pro bono group, says, do you have a contact at the bar I can contact about that question? Because it's pretty important to get an answer to.
I honestly, I don't. I would just call the main bar number, and they should be able to.
I've asked a specific question.
Okay. It's a fairly new rule, and that might be why they don't have a great answer for you on it yet. I mean, it's 2 or 3 years that they changed it. If you talk to me afterwards, I can talk to the actual, I can get in touch with the guy at ExxonMobil who was a big part of changing that. Maybe he'll have a good answer.
This is a big deterrent to getting people to turn out and volunteer.
Pardon?
It's a deterrent to getting volunteers.
Yes, absolutely. And that's part of the idea, is trying to make it as easy as possible for people to volunteer. We want to make sure that people are competent, but I guess the idea is if they'll let you practice in Virginia on other things, then they should let you practice on when you're giving free help.
Thanks.
Sure. So we're going to talk about it a little bit later. One of the obligations that you have in Virginia is to do pro bono hours. I had a guy named Jim McCauley, who was my professional responsibility teacher at Richmond. He works for the State Bar Ethics Council. And he referred to it as a sort of discretionary requirement, which makes no sense, obviously, but that's how the Virginia Bar treats it. You're supposed to do 2% of your hours each year to pro bono, but if you don't do it, you're not going to get in any trouble for it. I encourage people to do it, and part of the reason that we encourage you to do it is, other than, sort of you're supposed to, which I think supposed to doesn't make people do things very often. It's a good opportunity to enhance your skills as a trial attorney. It's a good opportunity, especially if you're practicing in the state level, if you're going around to get to know the judges. I think they're not going to treat you any differently, but when you go in and you say, hey, I'm appearing pro bono for this client, I think it helps you, it helps build your reputation in the community. If you look at people if you are interested in becoming a judge, most of the people that I know who are becoming judges now are people who have volunteered and who take pro bono seriously. It is something that a lot of firms, especially a lot of bigger firms, are taking more and more seriously these days. And it's something that they are able to project and present very well when they're advertising, and firms really do care about it. So let's talk about sort of the nitty-gritty of it. Again, if you want to volunteer, I've got Jenny Haberlin's number up here. She is the pro bono coordinator for legal services in Northern Virginia. She's, I think, out right now still on maternity leave. Do you know who's covering for her?
I think Nora Mahoney is.
And I'm sure that I can get the contact information to you for it. But there are a ton of different areas, and I'm sure they're covering for it. But that's the person to talk to if you want to volunteer for anything there. All right. So this is why it's so easy. 4 primary statutes that you need to know in order to handle protective orders. And we'll go through them. And there's really, in the definitions, there's only 2 definitions that you need to know. Everything else, and really the 279.1 is the one you're going to want to really focus on. That's the one that's going to matter the most to you. We're going to talk about the definitions first. In order to get a protective order, and I want to make sure we distinguish, there's 2 kinds of protective orders that you can get in Virginia. You can get a family abuse protective order. That's through the Juvenile and Domestic Relations District Court. And then you can also get one through the General District Court, which is called, I think, an acts of violence protective order. The language, other than there being a family or household member involved, is identical in terms of what you have to prove. So it's any act involving force, threat, or violence that either causes actual injury or places the petitioner in reasonable apprehension of bodily injury. All right? And I want to highlight a couple things there. Bodily injury is what is required. The number of times I have clients come in and say, well, he was really mean to me, or she called me fat, or things like that. And those are all not nice things to do. That being said, you don't get a protective order because of it. All right, emotional harm is not something that you are going to be protected against. It doesn't mean it's not an important thing. It doesn't mean it's not real. It doesn't mean that it might not be grounds for something else, but it is not grounds for a protective order. There must be either bodily injury or fear of bodily injury. They expanded the statute, it's probably 5 years ago now, 5 or 6 years ago now, in a way that I don't think it actually changed the definition. I think the idea was just to clarify it, that any criminal act that is involved, and they also specifically spelled out sexual assault as being something that could be covered. I think that anyone who's been threatened with sexual assault, how that wouldn't otherwise be violence, force, or threat resulting in bodily injury, I don't know, but they felt the need to do that, and so that's what they've done. Again, this is going to track, and you can really do the GDC ones as well, but that's really going to track there. All right, so that's what you need to be able to show. All right, these are the things that I want you to focus on here, or not and. All right, what that means is you don't have to show that that all of them happened. You don't have to show that a threat and actual injury happened. You just have to show one or the other. It can be anything. It can be a bruise. It can be if you slap someone, you may not be injured, but it's still going to hurt, and that's going to be sufficient to meet the basic standard for what an injury is. Pictures are fantastic for proving your case, as you would imagine. If someone comes in and says they punched me in the eye, and you're going to be 2 weeks or a little bit later going in before the court, having a picture of what it looked like the day of, a week later, 2 weeks later, are all going to be helpful. They always, it's like anything. A picture really will help make your case. And we've already talked about the new language. All right, here's the other thing that's important. For these specific ones, for family abuse protective orders, you have to show that it's a family or household. Remember, the definitions are really clear. Doesn't matter whether you're living together, except if they're in-laws. I guess you're allowed to slap your in-laws if you're not living in the same house. It would seem that the need would be there if you are in the same house. But so that's what it is. And what I want to focus on is, especially here, we've got people with children in common. All right, that means that if you've got that's basically covering unmarried people who have had kids together, and it doesn't matter whether you're still living together or not. It doesn't matter whether you're still together or not. All right. Also, a spouse or former spouse. If you are separated, if you are actually divorced, it doesn't matter if that's actually happened. It just matters that you once were. And then people who cohabited within the past 12 months. All right. That's in order to protect. Essentially, it's through the stalking provision that covers that. That's the idea. And also the phrase cohabited, which matters a little bit less now in terms of having to define it with the recent Supreme Court rulings, I should say. But that covers, and for a long time, I don't know if this is true all over Virginia, but in the Northern Virginia jurisdictions, everywhere I knew, covered same-sex relationships. And there's nothing in here that would suggest that we wouldn't be covering it now. All right?
So it doesn't cover just people who live together in the same house but otherwise have no relationship? Like
correct.
Students or whatever?
Right, yeah. Like if you've got a roommate that's just a buddy of yours, that's not going to cover.
That's not cohabitation.
All right? They're protecting that specific relationship. Now, if you have a roommate, you go to the GDC.
Yeah.
And you just apply there. You don't have to prove that. And frankly, the clerk is going to send you to where you're supposed to go. They do a really good job of it. Now, if I'm trying to get a protective order against my mom, which would be ridiculous, but I think in theory I could go to the General District Court. I don't have to get a family abuse protective order just because I have the familial relationship. I may not think that I need one. I may decide that I prefer to go there for some reason. I think they'll try and steer you one way or the other. In terms of what we're talking about with the family abuse protective orders and with the Attorney of the Day program, you're not really going to be involved in this process. You just need to be aware that it's something that could come up. But the clerks are so good with it that, I couldn't tell you the last time I really had to deal with this issue. All right, emergency protective orders, we're going to flash through this. These are the things that can be, and I probably cover it later, but let me also just make clear. In most other jurisdictions, in other states, they refer to these as restraining orders. Which is how people commonly refer to them. I don't know why Virginia chose to, other than we like to do things different. We're a Commonwealth and we're old and we just do stuff like that. That's what they are. So if you hear another state referring to it as a restraining order, basically the same thing, okay? EPOs have a specific statute. It's going to be very similar to the other protective orders. These are done in cases, these are supposed to be immediate. This is when the police get called and they see that there's been an act of, like let's say domestic assault and battery has taken place, and they can issue these, the police can, these can be issued immediately, and they're very, very short term, all right? They're done ex parte primarily, and again, you're not going to be involved in this process, but the point of these is they're just supposed to say, all right, this is to ensure that there's a period of time where we get the people separated from one another and where we allow the person who is the victim to seek additional recourse with the courts if they decide that they need to. All right? They last for 72 hours, but that's kind of. The reason I say that is they expire after 72 hours unless the time that they would expire would be a date that the court was otherwise closed. So you go on a Wednesday night, you get a protective order that would normally expire on Saturday, 72 hours later. You can't go to court that day, so it will continue until 11:59 p.m. on the first day the court is open following the otherwise expiration of the 72 hours. All right? Very limited remedies here. It really is just a stopgap measure. We're not going to go into it. It's prohibiting contact. You're giving exclusive use and possession of the residence. Here's something maybe we should talk about now. When we talk about exclusive use and possession of the residence, keep in mind it doesn't affect title. Okay? One of the things this court doesn't have the ability to affect title, and that's not something I think most people think about in their day-to-day practice. But if you remember, the circuit court's really the only one who can affect title, and so that can't happen in these cases. But you don't need to. It's just saying we're going to let you be in the house. It doesn't matter if you're on the lease. It doesn't matter if you own the house. Okay? None of that matters, but you can still get exclusive use and possession. All right? Preliminary protective orders. This is sort of the secondary stopgap. When you go in and you file a petition for a protective order, I want to make sure you guys have sort of the order of it right. So after you've got this EPO, and you're not required to get one, but after you get the EPO, you can go in and file a petition for a protective order. One of the remedies available in your petition is to request this preliminary protective order. Okay? So it's through the protective order petition itself that the P issue. The preliminary protective order lasts for, it's a really low standard, all right, probable cause that this has happened. These are done ex parte, so they're almost always granted. If you go in and you know what you're supposed to say, if you just go in and you say, I was hit by this person, it hurt, and I was injured, and I'm now afraid, and I want a preliminary protective order, you should basically get it, all right? The other side isn't going to be there. And I always say they're ex parte, which in the entire time I've been doing these, which is 10 years now, and I've, I don't know, handled hundreds of these cases. I've never come across an experience where the respondent was actually involved in this process. And that's because the respondent doesn't know what's going on, isn't required to get notice of it, unless they happen to be at the courthouse the exact moment that you go and do this and find out, they're not going to be involved. All right. If a preliminary protective order is issued, it starts the clock. You were required. So this is ex parte. That's a pretty rare thing to happen. The other side isn't given notice. That means that their due process isn't really being followed, right? That's not something that we traditionally think is okay. It's been recognized that in these particular circumstances, we may be willing to do it. As a result, it means that we have to have a final hearing on this on this petition for protective order within 15 days. All right? So it starts the clock, and these things move really quickly. That's another reason why I love doing these cases, is it's like anything. When you're working with clients, it's nice to have them in and out. So in theory, it's only if the preliminary protective order is issued is it required to be within this 15 days. If the preliminary protective order is denied, it could be set whenever, because there's no due process issue at this point. Most places are going to schedule it within the 15-day period, one way or the other, and that's just the way their procedure is set up. Preliminary protective orders can be extended, just limited circumstances. This is actually a fairly new thing. If you don't get service on the other side, which happens fairly frequently, because think about it, if you have this emergency protective order, the respondent has been kicked out of wherever they are, their normal place of abode, right? And we may not know where they are. They're not supposed to be in contact with the person anyhow. So it's not always easy to get them served. The Sheriff's Department will do service in these cases. It's free. And they take a priority on in the Sheriff's Department's office for being served. So it can be extended for up to 6 months. Preliminary protective orders can only be continued if the respondent asks for a continuance of this final hearing. Okay? And that's one of the things. Let's say you are handling a case for the petitioner in one of these cases. You walk in the day of trial and your client doesn't have a witness that he or she would need for that case. And you go up to the judge and you say, hey, my witness is unavailable, we'd like a continuance. Normally, in such a short period of time, that would be a pretty reasonable request and I would expect the court to grant it. All right? In this case, the only person that can request a continuance is the respondent. All right. So the easiest way for you to tell, like if you're new to these, and the easiest way for you to tell a judge that you don't really know what you're doing is to walk in as a petitioner and ask for a continuance because it's forbidden by statute. All right. The only person who can is a respondent. It's for good cause shown. Typically, that could be, you know, it really depends on the judge. I don't see them turned down all that often. Sometimes it's, I need more time to prepare my case. Sometimes it's, I need more time to get a lawyer. Sometimes it's, I'm just not ready to go forward today. They're going to grant it pretty liberally in those cases. And if that happens, the preliminary protective order is continued. All right, they'll issue a new one, but it'll be the same terms unless there's an agreement otherwise. If a preliminary protective order is denied, what it usually means is that you've got a crap case. And that's okay. I think those are the most fun cases to try. If you give me a case where you've got a picture of the petitioner coming in with 2 black eyes and a broken arm, it's going to be a pretty easy case. You shouldn't lose that case. The cases that are in the gray area are the fun ones to try. They're the ones that are interesting. And they're the ones, frankly, where having attorneys represent the clients is really, really helpful and really, really necessary. What I can tell you is in Fairfax, Arlington, Loudoun, and Prince William, they're still going to set it for a full hearing. All right, they're still going to put it out there. Alexandria, if they deny the preliminary protective order, at least this was their practice a couple years ago, they don't even set it for a full hearing. I don't think that's the right way to go, but the Alexandria court grants, it has probably the easiest place to get a protective order granted. So if they're denying your preliminary protective order, you have a really bad case in likelihood. So nothing's really been done about it there. Again, you're really not going to be part of this particular process. It doesn't mean it's the end of your case, okay? If you get a client who comes in and says, I filed for a protective order, I asked for a preliminary protective order and they said no, it might mean that they went in and when you ask for the preliminary protective order, it has to be based on either an affidavit or live testimony. It could be that they were nervous. It could be that 4 hours before that, they got the hell beaten out of them and they didn't know what they were supposed to say and they just couldn't get it together at that time. It could be that there was a language barrier, all right? There are a multitude of reasons why it might not happen. Again, probably means that they just have a bad case, but talk to your client about it, all right? It's a red flag, but it's not the end of the day. All right? There are more extensive remedies that are in here. Again, literacy, you guys can read through all of these. There's just going to be, it's sort of each step allows a little bit more because it's a little bit more involved process. One of the key things here, temporary custody of the minor children. This is a really big thing. There are 1,000 different reasons why people might not leave an abusive situation. A huge one is what's going to happen with the kids. I always say and I'm bad about this, and I should be better given how long I've been doing it. We always refer to this as domestic violence, all right? And what we ought to do is refer to it as domestic abuse. Violence is, and domestic abuse is about control. Anyone who's spent any time doing anything with domestic abuse will tell you that. That's really the key. All of these other things are symptomatic. They're just ways to control, right? Violence is a way to control. Economics are a way to control. You can say, if you've got a stay-at-home mom who's been home for 15 years, hasn't worked for 15 years, maybe doesn't have a college education, doesn't know what she's going to do, you say if you leave, you're going to have nothing. You're not going to be able to take care of the kids. All right? You're going to be homeless. I'm going to kick you out if you ever do anything about this. These are ways of control. Violence is simply one of those things. All right? These protective orders, they don't stop all of it, but they try to provide remedies for a lot of these issues. And kids is a big thing. All right, kids is probably the #1 reason why people who are in abusive situations don't leave, because they don't know what's going to happen with their kids. So what this does is say, we're going to give you temporary, very temporary custody of kids. All right? All right. So now, yes?
Does the PPO terminate the rights of the person to hold a firearm, or is that just the firearm?
I think any protective order will. And so I forget from time to time, there's two different, there's the state statutes and then there are federal statutes about protective orders. One prevents possessing, one prevents, I think, carrying, but cumulatively, you are not supposed to have firearms. And in theory, they should be turned over to law enforcement when one of these is active. All right? It's imperfect. All right? Because part of it is, if I have a gun and you don't know I have a gun, and the judge says, do you have a gun? And I know it's hard to believe, I lie and say, no, Your Honor, I don't have a gun. There's not much we can do about it. Even if I know that there is one. If I don't know where it is, if it's been hidden, I mean, all someone has to do is say, no, I got rid of it. And so it's tough to enforce, but they're getting better and better and better about it. If you have a client, and so maybe this is, being in the private bar now, I'm on the other side of this considerably more often than I used to be. If you are representing a respondent, and they ask you about that, the safest course of action and the best advice is to tell them not to have one. All right? And they should be able to turn it into the sheriff or the police.
Can I ask you, in Fairfax County, do you actually call clerk's office to appear in front of the judge for preliminary protection order?
All right, so you're going to go file in Fairfax County. You'll go to the domestic intake, and you'll. It's a fairly lengthy and slightly laborious process. There's not much to be done about that. They try and streamline it as much as possible, but that's where it'll start. You'll go through domestic intake, and then they'll go through that. They'll help you draft up your petition, and I'm as the petitioner. All right, and they'll have you draft all of that up. They'll go through the process, and they'll give you a choice now in Fairfax, and they'll say, do you want to do an affidavit, or do you want to do live testimony in order to get the protective order? Thank you.
Just in case we understand.
All right, I appreciate it.
Mm-hmm.
And so you'll start through intake, and they'll eventually get you to, and I think they do them all at the same time, basically, like around 1 or 2 o'clock now, where you'll appear before the judge if what you want to do is do the live testimony. If you do the affidavit, which is sufficient, then it will be submitted to the judge. You just gotta wait around for the chambers judge to be available to review it and decide whether to issue it. All right. If you guys are going in, and this is not through the Attorney of the Day program, obviously, but if you're going in representing someone who's a petitioner and they want to file, you can draft the petition for them. It's an affidavit and petition together. They have to swear under oath that these things are true. Okay? And you can just draft that as you would draft any other pleading and submit that to the court. You don't have to go through the domestic intake. They may make them do some of that, and they're going to want to be there because the issuance of the protective order, the judge may have questions that they want answered, so you're going to want your client to be there with you. So we talked about this already, the active family abuse. The other thing you have to prove, and this is what, and people forget this all the time, and I think frankly some judges forget it all the time, or they sort of think that it's sort of manifest once you've proven the other. But you have to prove that an active family abuse has occurred, and then you also have to show that a protective order, which is an extraordinary remedy, all right, is necessary to protect the health and safety of the petitioner. All right, so if you've got a situation where you've got respondent beats up the petitioner, and then the next day leaves for this crazy Mars trip that everyone's on, or that people are talking about. Not that everyone is on, we're not there yet. Like people are applying to go on this like Mars trip, right? And someone takes off and goes for that, or goes to the South Pole and is going to be there for the next 3 years. All right, you've got that. You can prove an act of family abuse, but if they're at the South Pole and there's no way for them to get back, do we really need a protective order? All right. If they have gone to jail, do we really need a protective order? Now, my experience has been that protective orders, if they're just in jail, first of all, we don't know if they're going to be found guilty. Second of all, if you are in jail in Virginia, domestic abuse is a Class 1 misdemeanor, which means it's punishable by up to a year in jail and up to a $2,500 fine. But there's also a diversion program, which if it's the first time that you've done it, you essentially plead guilty, there's a deferred finding, and it will be wiped off your record. Okay? So they're probably not going to stay in jail very long. These are there's 1,000 different things that could say why you don't need it. Most of the time, if you can prove that, it's pretty reasonable that if it's a pretty significant act of family abuse, it's pretty easy to prove the second part. Let's say, all right, this is an example I had when I was probably about 5-6 years ago. We had a client come in who had found out that his wife was sleeping with his best friend. And when he found, like when his wife, I don't know if she told him or how he found out, he slapped her. Now, you are not supposed to slap your wife, even if you find out that she has been sleeping with your best friend. She asked for a protective order. All right, now we know an act of family abuse has occurred there, but there's no history of it. It's clearly in relation to a very specific trigger. Is there really a worry that he's going to, once he's calmed down, 2 weeks later, a month later, 6 months later, that he's going to do something like that again? That's where this comes into play, in cases like that, where it's a little bit more gray.
In your example about if the respondent goes to jail, and say he's going to jail for charges other than the domestic abuse, so
Right.
so it may be longer than a year.
Mm-hmm.
So there's not that worry, but the protective order would protect against phone calls. Would that be sufficient?
It could be. I mean, if he's not making any phone calls, then, like, let's say it's been 2 weeks and he hasn't contacted her at all. I mean, it might well be. All right? I think most of the time, even if they're in jail, there's going to be a pretty good argument for why it's needed. You don't know when they're going to get out of jail. You don't know what the result of the charges is going to be. We have this, nuisance of being innocent until you're proven guilty here. So I think that even if they're in jail, unless it's, and maybe that's the other thing. It could be that certain remedies aren't provided in the protective order. Okay? It might be that they just say no contact. All right, and we'll talk more specifically about the remedies in a little bit. And Laura, will you yell at me as time is getting closer?
I'll let you know when we've got about 15 minutes left.
Okay. So a lot of people call these permanent protective orders, and if I can make sure you guys do one thing today, when I'm done here, it's that you won't call them permanent protective orders. They are not in any way permanent. They can last for up to 2 years. All right? And the reason that I rail against it is when we call them that and our clients hear that, they get a different expectation. They think permanent just because, and I've heard judges call them that. I've heard attorneys who've been practicing, longer than I've been alive call it that. And so just focus on that. It's not permanent. It's just a family abuse protective order. Now that I've said that they're not permanent, in theory, I guess one could be. After the 2 years, or as the 2 years is approaching, you can always go back to court and request that it be extended. So this law was written and it was put into place in 2010. Very well-intended law, very poorly written, in my mind. The law says that in order to protect the health and safety of the petitioner, a protective order may be extended for up to another 2 years. What do you have to prove? There's no case law on it. First of all, because it's fairly new. Second of all, because these things just don't get appealed all that often. There's very little protective order law, case law in Virginia one way or the other. So let's say I've got a client who says 2 years ago, or a year and 8 months ago, I got a protective order because my husband, beat me up, punched me twice. I got a protective order. It said he couldn't have any contact with me. It said he couldn't have any further acts of abuse, and it said, he had to stay out of the house, out of the home. He's done all of those things. That being said, this was a really traumatic experience for me. I'm still afraid of him. I think that the only thing that has kept him from having contact with me is the existence of this protective order. So I would like to extend it. And the husband says, "Oh, wait just a second. It's good for up to 2 years. I was told not to have any contact. I was told not to have any further acts of abuse, and I was told to give her exclusive use and possession. I've done all of those things. I don't need another protective order. I've learned my lesson." So we don't know yet, and it really is going to depend on what jurisdiction you're in and what judge you're in front of, whether an extension is warranted. From what I've seen, and this is just anecdotal, what I've seen from other attorneys is that it's usually tied into the seriousness of the event that led to the initial protective order.
You talked about how it doesn't include title, so presumably if you're after 2 years and they've separated and it's a jointly owned home, you would imagine there would be an interest in selling the home.
During that period of
What
time,
happens
I would
then?
imagine that they would have gone through the divorce process.
Yeah.
All right, and that will have been reconciled through that.
Yeah.
All right, and we'll talk about this, and I don't know when it comes up, to be honest. But so we're going to go through a few things here. One of the things is that a protective order can always be modified or terminated by either party. Can move to do that. So 6 months in, either, and this will happen with more regularity than you would believe. People will reconcile. Somehow and it's all tied into. When I first started legal aid, I think when anyone first starts out and starts learning about domestic violence, you always think, and the number of people I've heard say, "Well, I would never put up with that," and that's very easy to think. And I think probably everybody here thinks the same thing. I would never put up with someone who's supposed to love me being abusive to me. First of all, I would say we all put up with some really stupid stuff in relationships, right? We all do. That's just, I think, human nature. But you never know until you're in that situation. There's so many different things. And so the best thing you can do when you're working with clients is to suspend your judgment on that. If you were here illegally and you didn't know that you could go to the police, you thought you might get sent home. Maybe you're here illegally, but your spouse isn't. All right? Maybe you're here illegally and your kids were born here, and you're afraid that you're going to get sent home if you ever go to the police on anything. All right? So the best thing you can do, really, and I'm not saying like put yourself in their shoes, but none of that. Suspend your judgment about why they are in that, and just try to help them get out of it. All right? That's the best thing I can suggest to you as far as that goes. All right? There are way more extensive remedies than certainly the EPO. There's a couple additional ones. The two things that are really going to be in every single protective order are prohibiting further acts of abuse is in every single protective order, because why would you get one if you weren't going to have that provision in there? Prohibiting further contact is in most, all right? And it can be various permutations. Sometimes it's no in-person contact. They might have kids together, and there might be the number of people who come in and will say to me, "Yeah, he's a great dad. Yeah, he beat the crap out of me, but he's a great dad." And they want the kids to continue to have a relationship with the father. In order to arrange visitation, you might have to have contact. So there might be something that's carved out that says via email, via text message. If you're going to do that, if your client wants that, I always want it to be text message or email, because I want evidence of what the communication is in case. Now, that can be a double-edged sword. All right, if your client texts the person she has a protective order against and says, I miss you, I wish you were here, and then he comes in and asks to modify the protective order and says, she's not afraid of me, look at this, that can be a problem. So advise your client about that. We tell, when I have clients sign the retainer agreement in my firm, we also give them a disclosure form that basically says, any email that you send, any post on Facebook, wherever, any text message that you send is a potential exhibit in a case against you. Don't be an idiot. Clients will be idiots. But you need to make sure you advise them about that. Okay? You can also include prohibiting contact with family or household members. Now, those were described above, but this is a good way to start. And you're certainly welcome to. You can contact Ellison V to find out. You can contact me and do that as well. I'm still very involved in helping them. Like Fairfax County, if 7 cases came in to me for a day, I would ask for help. All right, that's a ridiculous number. It's impossible to prepare well for all 7 of those cases. Okay, but that's the general idea behind it. And then you get the cases, and you're going to do your regular conflicts check. And then you're going to set an appointment with this client. All right, and we tell the attorneys, get in touch with the client. We tell the client, get in touch with the attorney. All right, all you're committing to is to evaluating their case. All right, and if it's a good case, or I shouldn't even say a good case, if you believe what they're saying, all right, it's I guess the basic standard you would have for any client. If they have a good case, a case that can, where they're alleging the appropriate facts, then we expect you to take it. Doesn't mean that you're going to win. All right. As I said, I think the cases you might not win, the more comfortable you get with it, are going to be the ones that you find most interesting. But that's all you're doing is saying, I'm going to meet with you, I'm going to talk to you about your case, and if it's a legit case, then there's an expectation, but not a requirement, that you represent them in court. Things you should be aware of when you do that. Cases that we talked about, they get continued. So while the idea is that you're committing one discrete day, if it gets continued, there will obviously be a requirement that you return once you've made that appearance. But at that point, you'll have your schedule, and you'll have to make it work with your schedule as well. You will be covered by, as long as this person qualifies for LS&V services, you will be covered by their malpractice insurance for the cases that you do. Okay? And that can be an important thing. Hopefully it won't be needed. And the good news is, and this is the other thing I tell people, these are important cases and they're serious cases. We're talking about, cases of the murders that take place in Fairfax County each year, which are not many. Most of them are domestic violence related. Okay? These are really serious things. But you're in the juvenile court. If you screw up, appeal it. All right? It's a pretty low pressure situation. All right? It's almost, you get a free crack at it. All right? So that's how I would look at it. The other thing I'll tell you is, when I first came to work for LS&V, and I was the domestic violence staff attorney, the very first case that I took to trial for protective order, and I had my boss watching me during this case, and I spent, way more time than I probably ought to have preparing this, but it's the first one, you want to prep, blah, 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 blah. So I said to my client, well, in between when this last incident happened and when you filed for the protective order, there's about a 5-day period. Do you have any contact with them? No contact. Well, at trial on cross-examination, now, and so here's the thing, if I'd known, I could have just brought that out as part of our case in chief, and it wouldn't have been that big a deal. We could have explained it away. But she denied having any contact. But then on cross-examination, she said, well, yes, he did come over to my house. And they said, well, isn't it true that you guys spent about 4 hours together that day? And she said, no, that's not true. We said, well, how long did you spend together? She said, well, it was close for like 2.5 or 3. And then he said, isn't it true he came into the house to talk to you? And she said, no. And he said, well, what did happen? She said, well, he was in like the threshold of the door is where he was. And he said, isn't it true that you guys went to McDonald's together? And she said, no. I said, well, you guys didn't go to McDonald's? She said, well, we went to McDonald's, but we drove separately. There was a playland there, I get it. How do you resist? And then he said, wasn't it true you guys then went to, when that one, the playland was closed, you went to another one and you drove together to that? She said, yeah, that we did do. So at the end of the day, in my first case, my client not only was protective order denied, my client was ordered to pay $1,000 in attorney's fees. Because clearly, I think she had, and this is a case where she had a bruise on her eye. She looked like she'd been punched in the eye, and she testified to that. And I think that that's what happened. But because she wasn't truthful about basically anything else, it sounds like, we ended up getting a really bad result. The moral of that story is, it's not, like, your first time can't be worse than mine, all right? I had a legal aid client who had to pay $1,000 in attorney's fees, and my boss was watching, and it was my first one. So, so hopefully yours will go better than that. And the other thing I should tell you, if you have any questions about the process of it, I think there's documents that were provided to you from LS&V about exactly how it works, but that's the general framework. We're asking people to commit. Whatever you can commit to is great. If I can put you on the calendar, when I say quarterly, we're talking 4 days a year that you're committing to it. It's not that much, and you'll know as far out as possible as you want when you're going to do it. It's like scheduling a vacation day, but with a little bit less fun than vacation. LS&V does way more than just family law and way more than just protective orders. And there should be information in your kits, and I want to encourage you, if this is not your particular thing, and I get it, there are certain people who just say, family law, I don't want to touch, it's miserable, and there are days where I agree with you. But there are housing cases where someone's getting kicked out of, whether it can be Section 8 housing, or they're just getting kicked out by a landlord and maybe it's not being done the right way. There are consumer disputes. There's bankruptcy. Basically, when you think about it, almost any area of law that anyone here does, there's going to be an application somewhere that people need. Wills and trusts, all right? And trusts are unlikely to be needed for a legal aid client. I think we would have to wonder about whether they're being totally truthful if they need it. But end-of-life documents are things that everybody needs, right? It doesn't matter if you're rich or poor. If you don't have an advanced medical directive, that could be a problem for you. There's almost anything that you do, there's going to be an indigent person who needs help with it. They do work for kids who are special ed. They do work for the elderly. There are elder abuse cases that people get involved in. If you're interested, they can figure out a way, and there's not a particular program that strikes your fancy. Trust me, they can figure out a way to get you involved. There are just an infinite number of things, and I'll tell you this right now, just to give some perspective. So Fairfax County has between 1.1 and 1.2 million people in it. For family law, they have 2.5 attorneys who are handling family law cases. All right? There are maybe 2 attorneys handling housing cases. Won't be surprised to hear that legal aid is not a particularly well-funded organization, and it's gotten worse in the last decade. I was smart and left, and then I was stupid and came back and worked for legal aid again. And basically, right after I came back to legal aid, Congress went, no, not going to fund you anymore. All right, and so there's a huge deficit of help for people who really, really need it. And then there's when we talk about pro bono, it doesn't have to be through legal aid. There are a ton of different organizations throughout, and like I said, it can be anything. I encourage you to do the pro bono work. If it's not legal aid, as we talked about, if you're making $32,000 a year and you've got a kid, you may not qualify for legal aid services. That doesn't mean you don't need help. And there are other organizations that aren't bound by the federal regulations who can provide that. All right, so whatever you want to do, if you've got questions about what other places you might be able to go to, what other areas you might want to investigate, contact me, contact legal aid. I think I have, all right, this is the very last guilt trip part. This is the actual rule that tells you what you're supposed to do. My office number and cell phone are in there. If you have questions, particularly if you take any of these cases for protective orders, call me whenever. And if you have a question about it, I'm happy to answer it. I'm happy to help. My feeling is if you're volunteering your time to do it, I don't mind helping out. All right. And the alternative is if you are in practice and you're handling one of these cases and it's not pro bono, but you still have questions about it, feel free to call me as well. I'm happy to chat with you about it. But get involved. It's a great thing for you to do as far as your professional development. The number of connections that I've made through doing that work has been invaluable. You get, especially if you're a small business, you get clients from it. You'd be surprised. And you're not necessarily going to get, if you're working in legal aid, you're not going to get someone who says, well, I know I didn't have money to pay you for a protective order, but I've got 10 grand to pay you for a divorce. That's not going to happen. But the people that you meet, the other people who are involved in this program, the judges that you're going to become involved with and get to know better are really good resources. And so it's a good thing for you in that. Anyone have any questions for me? All right.
All right, well, thank you so much, Dan. We really appreciate
Sure.
it. We're going to take a 15-minute break now. If anyone has any specific questions for Dan, I'm sure he doesn't mind sticking around for about 15 minutes. But feel free to get up, move around, help yourself to what's left, and if you could be back at about 11:15. Thank you.
Oh, yeah. You get any word from the MCLE board yet?
Well, I want to show you exactly what I got. Why won't this turn off? That turn it off? Oh my gosh.
I've never seen the MCLA board be this.
Does anyone know how to turn this on?
Broadcasting live.
I'm pressing the red. I'm pressing this. I shut the thing. I have.
Shut the cover now? Like close it?
Oh, like shut this thing. It's still recording though. Oh my gosh, this is so
Is there a
frustrating.
cover on top? Didn't you say you just put the cover on and off?
I did.